Mr. Sikri is back with us. So, welcome back to the sea. There was a problem with the network. So, we were talking about the implications of this case and how Pakistan's role is going to be ascertained in making sure that, what the world already knows, it begins to believe.
Yeah, sorry, actually I got disconnected when I was talking. Can you hear me now?
I can hear you loud and clear, sir.
Okay. No, what I was saying was actually Mr. Mukul Rohde has covered some of those aspects which I wanted to share with you. First is that yes, it's a victory for India, no doubt about it. And any extradition of such fugitives is not an easy job, notwithstanding. I mean, the treaties, extradition treaties there and legal regime there. You have to not only fight a legal battle but a diplomatic battle as well. And no doubt that Indian government has done well for itself in ensuring that he comes here. Uh, but when it comes to this treaties, under the treaty, when he has been extradited, there are two or three things which have to be seen. Number one, he can be this prosecuted only for the purpose for which he has been extradited, and the charge which was I mean leveled against, or charge which has been leveled against him, and on which, because the extradition takes place only when I mean the government of that country is satisfied that there is a sufficient material for him to be prosecuted, and therefore it is keeping in view that particular offense for which he is charged by the Indian government, and therefore he will be prosecuted for that. Now, another thing is which we have to, and that is in our extradition treaty with the US as well, that there cannot be any which in any case our own law also prohibits, that there would not be any police torture, custodial torture, and when he is going to be investigated and interrogated, it will be ensuring all fairness and no corpus punishment, etc., of that nature, or no torture of that nature. But then coming to the question of evidence, etc., yes, as Mukul has also said, Indian government has its own dossier, and then there is sufficient material which is shown to the government in US and the courts in US, on the basis of which they have agreed that yes, I mean, there is sufficient material that he should face trial. And having said so, there may be one thing, of course, whatever comes and with these, I mean, when the interrogation, etc., takes place. So during that period, how much he would be able to, I mean, share the information, or he will be forced to share that information, that is yet to be seen. So therefore, it will depend on that. There's one thing, of course, one silver lining in addition to what Mr. Mukul has said. Let me tell you that look, when he was prosecuted in the first instance along with Headley, and they were charged of that you have done what we call material support to LET at that time, insofar as this particular incident is concerned, which happened in India, that carnage which happened in India. And there was conspiracy for material support and actual giving of that material support. Both the charges were there. He was convicted of the first charge of conspiracy, but when it comes to giving this material support, he was acquitted by US court. That means that charge could not be proved on the basis of that evidence, and therefore now the charge is that material support. So on I mean, if it could not be proved, and he had tried to say that also, since I have already been tried in US courts, and I have been convicted only of one offense for which I have suffered the punishment, why I should be tried again? And this is what we call double jeopardy, that one cannot be tried for the same offense twice and punished twice. But fortunately, this double jeopardy principle doesn't apply, because he has been tried by US court and not by Indian courts, as per the I mean, for violating Indian law. So therefore, the U.S. court did not accept his argument of double jeopardy. And but another significant, I mean, development which took place thereafter was that when Headley was thereafter charged, he became approver. Because you see, in a case of conspiracy, as we say that conspiracy always happens in dark, when the two persons or more than two persons are having that conspiracy, naturally the world at large would not come to know about it. So
All right,
therefore,
sir.
normally in such cases, police, what they say, they try that if one of them can become approver. Approver means that yes, he would confess that yes, what happened, and he will spill out the beans. So therefore, if one of them becomes the approver and says that what actually happens, and that person who becomes the approver, not that he would escape the punishment, but yes, he would be treated lightly insofar as the punishment is concerned. So
All right,
Headley
sir.
became approver, and Headley then said, no, he was this material support was not only conspiracy, but actually it was given by Rana. So therefore, that evidence is there in the court on the basis of which this conviction took place. So that would be very material evidence for India, that because it is in court records there. How much that would be relevant, because we have under our Indian Evidence Act that the evidence which is relevant for our purposes can be taken and not irrelevant. So it has to meet the test of relevancy, legal test of relevancy. That would be seen.